If you're using AI in your MSP, do you know what your legal exposure is? What happens if a client goes rogue and uses AI tools? And what's your risk? Like what happens if your client uses AI tools and you didn't know about it? And what steps should you be taking in your MSP to reduce the risks of all the AI related things that are happening out there? Because there's lots going on in the world that we don't exactly have great answers for. If you have any of those questions, today's episode is for you. Today, I have the pleasure of talking to two of our industry's best legal minds, Tom Fafinski from Virtus Law and Brad Gross from the Bradley Gross Law Firm. And today's conversation is going to be all about all things legal and AI in your MSP. My name is Adam Hammond. Welcome to Ramblings of a Geek. And I'm really excited for our conversation today. So let's get started. If you ever hear me talk about legal stuff any place as it relates to anything MSP, you're going to hear me mention these two gentlemen's names because they are both excellent at their job and there's plenty of business out there. I always recommend people talk to both of them because you probably will gel with one or the other. And so I'm really fortunate to have both of them here today. We're going to be talking about the impact on AI in the legal side of MSPs and some of the things you should think about as an MSP relating to AI in particular. So Tom, do me a quick favor, give us a little bit of your background, and then we'll have Brad do the same.
Oh, yeah. Yeah. So when I was in law school, I worked at a company, subsidiary of Emerson Electric. And because I was the youngest guy there, they gave me all the tech stuff in the corporate department. And that's how I kind of got exposed to the technology side of law. And I went out on my own after they had offered me a position, but they were kind enough to come out as a client of mine. So I helped them with the licensing and things like that, dealing with refineries and some bigger type issues. And it evolved to where I was doing legal work for technology consulting firms that were implementing ERPs and CRMs in the 1990s. And then my brother started a break fix company in, I think it was 1998. And he came to me, and of course, I helped him because he's my brother. And then, as it turns out, boy, that guy helped me out a ton because as his company grew and his relationships grew, he started sending me MSP friends. And so by about '06, '07, most of my new clients were really MSPs, and it kind of took over. We do some estate planning, mostly for MSP owners now because M&A is so hot. I have been in the industry and really focused on the MSP sector for about 20 years. Yeah.
Wow. Very good. Brad, why don't you tell folks a little bit about you too?
So my background's a little bit different. I started out as a computer hacker at the age of 11 on my TRS-80 Model 1 Level 2 16K, which I still have in my office. It works. Hacking into municipalities and, through my 300 baud modem, seeing what havoc an 11-year-old could wreak on society. Eventually, I became, out of law school, a prosecutor and started putting the people like me in jail. Well, I think people that were a little bit more vicious than I was.
Fair enough.
So I did that up in New York. When I transferred to Florida, I was a assistant state attorney down there, and I founded the Internet and Computer Crimes Division down there. And then I realized that government is probably the best job I ever had, but unfortunately it didn't pay enough to support a family. So we went out into private practice back in 2000, representing tech companies because that was the nature of what I knew and did, and been working in the industry ever since, representing MSPs nationwide. So here we are. It's good to be on the panel with my friend Tom.
Well, whenever I talk about legal, I always talk about legal in the business context, right? Because I'm no lawyer, but I spend a lot of time thinking about it and talking to MSPs. So, I defer all legal things to you guys, but I like to help frame legal stuff in the business context, which is sometimes a thing that gets missed, especially when people are grabbing a contract template off of a insert random repository here. So I try to give them some context and steer them to getting some help appropriately in the world. So let's kick it off because I think that we're going to find that you guys are going to agree a fair amount, but there may be some different contexts of conversations to get out there. So let's start off with the first question, which is really when we think about the AI tools and when a client or an MSP is using an AI tool, who ultimately carries the legal risk if something goes sideways, right? Is it the MSP, the client, the AI vendor? And Brad, I'd love it if you would start with your answer, and then we'll kick it over to Tom.
Yeah. So I think that it depends on the scenario. And let me tell you what I mean by that. There's a legal truism that you can delegate a duty, but you can't delegate responsibility. Okay, you could delegate a duty, can't delegate and divest yourself of responsibility ultimately. And I think that along those lines, when it comes to AI, the way I see it is I like to split it into two different areas, okay? First person and third person, and how the word providing an AI solution is defined. So let me give you an example. First person, you're an MSP. You are installing patches, you're doing load balancing, you're configuring things, you're actually providing that service, okay, to a customer. And let's say you're using some sort of AI tool to do that. Well, if AI goes wrong, if there's some issue, right, that goes wrong, hallucinations and so forth, ultimately, that's on you, the MSP. And just because you used an AI tool and it did something wrong, you could delegate the duty of doing things to the automated process, but you can't delegate the responsibility. Ultimately, in that scenario, first person, it's on you. Um, I would separate that from third parties, right? Third person scenarios where you are bringing in an upstream provider, whomever it is, okay? And they are actually providing the service directly to the customer. You are only facilitating the relationship. And assuming that your MSA, your master agreement, makes clear this type of paradigm, I do believe that you can mitigate responsibility for an AI problem that occurs on a third party solution from a third party provider that you are not providing, you're facilitating. You'd be able to mitigate your responsibility, if not eliminate it. So I do think, long winded way of saying, depends on the scenario. Is it first person? Is it third person? If it's first person, you might have a problem. Third person, I think you can mitigate.
Tom, what do you think?
I agree with what Brad said, and I think that what we're going to see in the marketplace is that there will be cost pressure on MSPs to provide services at a lower rate because of MSPs, the industry itself integrating AI into the solution and eliminating a lot of like tech, first tier type of stuff. And so I think there is a way through communication in the MSA, your master services agreement. I think there's a way to try to shift some of that risk in exchange for acknowledgement that this risk is being shifted in order to provide lower fees. This is not something that has gotten a lot of traction thus far, but I think that there's going to be a way to kind of shift that a little bit. And then when it also comes to who's using the AI. If the MSP is using the AI, what Brad says is absolutely true, unless you have that language that tries to shift it. And good luck on that. I think it's going to be hard, but I think it's probably worth the try. But if the client is implementing the AI on their own and the MSP knows about it, I think there's a real danger there. I think you're going to have liability for not adequately advising them unless your language in that contract identifies that, hey, we're not doing that stuff. Even if we know about it, we're not going to do it. Think of it like a co-managed environment. And you're saying, okay, we're not a co-managed environment, but you want these lower prices, so we're going to go co-managed as it relates to some of these lower level items. I think it might be possible to do that, but I think it comes down to how the contract allocates it, and judges are going to read these MSAs against the MSP because when you think about the relationship, this company that doesn't have any specialized technology and is seeking to outsource it is depending upon you to do something that's market rate too. So I think a judge could look at it and go, how would they even know? You're the person that's supposed to be telling them that this is an important area.
So where would that language live? Is that in your MSA? Is that in your whatever you're going to call the service document, whether that's an attachment or a service guide or whatever? Like, where does that live?
So it could live anywhere, but I think my preference is I like to make the customer sign multiple things because the relationship is evolving and growing with time. Things change like AI. So I want to train that customer to be constantly signing things for new services that you're offering. So um, I like to structure the managed monthly monitoring type stuff, activities that we're doing. I like to have that as a separate addendum. And I like a lot to have a memorialization that they've declined certain services. So, for instance, and think of it like a check the box thing. To have in your stack of things that you're doing for them to say, we talked about AI training and AI monitoring for you, the client, not not the MSP's use of the AI, but the client's use of the AI, and you've declined that service, and you've checked in. Brad, I listened to an episode that you did a long time ago, and I really liked it. It has to be a meaningful um, waiver that they have to understand what they're doing. So that declination that's memorialized in that monthly managing services addendum should really specify what it is they're saying no to and the exposure that they're undertaking. But the reason why I like it is because our clients grow, our MSP clients, they grow. And with time, they choose to do more things. So when you come in and do that periodic business review, you can say, you said no to AI training. You said no to AI monitoring, or acceptable use policy monitoring or auditing. You said no to that. Would you like to say yes now? Because for that we charge X dollars per seat or per device or however you're charging, and I think it gives you an opportunity to grow your revenue. Because I want, and I know you do this too, Brad. I want that MSA and all of the addendum that are getting signed, the statement of works for location changes. I want that to grow the revenue of the MSP. I want that MSP to get 10% organic growth just because they exist with this customer, through the growth of the customer, through the additional services, and of course through automatic price increases.
Brad, what are your thoughts? Where would you expect to see this, or where would you put this in contract language?
I think that the key to all this, and I agree with Tom that it could live anywhere, right? It could live anywhere, but it should live everywhere. It could and should live in your MSA, yes. But also, I think that, and this is just sort of a different way of saying exactly what Tom said, I think that it's all about the communication, right? It's all about communication with your customer. And what MSPs will sometimes find, or feel rather, is that they don't want to communicate too much because they feel like by saying things are going to be bound to certain standards or certain services, and they're going too far. But the problem is when they don't say anything or they say too little, the rules, it's not that the rules don't exist. The rules just become created by the customer, not by the MSP. Right? And the customer's rules are always going to be good for the customer and not so good for the MSP. So it is my suggestion that, when it comes to where do these things live? Yeah, in the MSP. Yeah, in the quotes. Yeah, in quarterly business review, written reviews and updates. Yeah, put it as often as early, like they say, vote early and often. Put it as early and often as you can, because more communications displaces mismanaged expectations. And that's what you're trying to do. You're trying to displace mismanaged expectations so everyone's on the same page.
I find that, Brad, that MSPs, by their very nature, they're like Midwest nice. They just want to be nice. We're going to be customer service, or we're going to do this great stuff for you. Don't worry about it. We got it all taken care of. And they don't tell them the truth. And the truth is, a cyber attack or an event, a breach of some security breach of some, is devastating to their business. And are you sure you want to say no to this? Because this is what can happen if you say no. And I don't mean to say scare them with the truth or sell out of fear, but I see MSPs refusing to sell fear because they're just trying to be nice. And there's a balance. You don't have to like scare the bejesus out of them, but you can tell them the truth, that it's critical that they understand that their employees are going to use AI whether you sanction it or not.
Right?
So because their life is easier.
I agree. And I think that if you don't sell the truth, If you don't tell the truth and you don't try to push the fear, what happens? Well, they decline a service. Okay, then something bad happens and they point the finger at you. And you're going to say, yeah, it's not going to be a defense that says, well, I didn't want to tell you the truth. I didn't want to scare you, because we're all friends until we're not friends, right? And at that point, we're not friends anymore. And now that client's going to turn around and say, you should have pushed it. You should have told me. What the hell? This is your business. What did I know? So I agree with you. You gotta, yeah, as weird as it sounds, you have to sell the fear because the world is a scary place. It is.
Well, and you don't have to go real far to find situations where a company used AI tools and didn't have regulations in place, and they like let company secrets go to the entire
Oh,
world, right?
or
And
or
so,
or PII, or
right.
personally identifiable
Yeah.
information, and then
They
you're
didn't set up,
subjecting yourself to governmental scrutiny.
yeah, they didn't set up the boundaries. You're right. Hmm.
So so then let's talk a little bit more about this kind of this shadow AI side of the world because I kind of we're kind of heading that direction anyway. So Tom, like when we think about some of the shadow AI side of the world, employees are using unimproved tools. Like from a legal standpoint, like what risks does that create for the client? What risks does that create for the MSP, and how should MSPs kind of handle that?
So it goes back to what Brad said, that you can delegate the duty, but you can't delegate the liability. So if the MSP says this engineer is going to do the work, or this tech is going to do the work, and that tech on their own decides to use AI, sorry, MSP is liable. I mean, it's just unless you have language in there that says that our techs, but especially like if it's unauthorized AI, like let's say certain tools have been approved and certain haven't, and they use the certain that haven't because it's just easier for them or something like that. The MSP is going to have exposure on that. So you should have like an authorized use policy within the MSP. The client should have an authorized use policy as well. And if you're looking for a new revenue stream, coaching them on doing the authorized use policy for your client and monitoring that and auditing that brand new revenue stream for MSPs, and a beautiful revenue stream because the client, they have no idea how to do it, but in principle they understand that they don't want to, you know, divulge proprietary information or personally identifiable information, and they kind of glom onto that, especially if they're healthcare providers or have to comply with the financial requirements. Yeah, I think that's probably, where you have to go with the as the MSP is adopt that authorized use policy, monitor it, audit it, use yourself as practice, and take it from there.
Yeah. I think that and following up on what you're saying, Tom, and Adam, your question about what shadow IT. It has presented so many issues that we've seen over the past 2 to 3 years. Really, it's not like something that's been going on for decades. It's a fairly recent phenomenon, but what we have seen is the shadow IT's use of AI has created security vulnerabilities, okay, that impact the effectiveness or the efficiency of a existing endpoint protection. We have seen uh, MSP's clients just supplanting the advice of the MSP, right, in favor of what AI told them to do. And that, of course, is almost always a bad thing. It's almost always it doesn't work out very well for the client because the AI doesn't understand the global architecture of of what's going on. And we've also seen shadow IT violate the terms of EULAs and service agreements that the MSP has with upstream providers, right? Sometimes, for example, an upstream provider, especially in the security area, will say, you cannot probe our systems, right? You can't scan our systems. You can't conduct any pen test. Well, here comes Shadow IT. They install AI, and the AI starts to conduct a pen test or scan, right? Not only are you disrupting the process from your own MSP, but you are also causing the MSP and maybe your own organization at that point to violate the EULA of the very software that's installed and that you've been using. So it presents a lot of issues, and I think it's definitely an issue, a topic that needs to be addressed.
I had an MSP that was just, we were talking about AI and the opportunities of AI, and they were being engaged to build an agent for the purposes of screening applicants for positions at one of their clients. And I'm like, "Oh, you don't wanna do that." There are so many, laws that protect employees and applicants and, like discrimination. Have you heard of discrimination? Uh, automated hiring is not something you want to get behind and build that agent. And because they were actually building the agent to review, they had like 100 some resumes come in and they were trying to screen it. And it may be a good, efficient idea to do it, but oh my, you are really opening yourself
Well,
up if you
you
don't do
see,
it
now
correctly.
that's the difference between Tom and I. So Tom would say, you really don't want to do it, and gee, that's a bad thing to do. I would say, yeah, you don't want to do it, it's a bad thing to do. But if you do, here's my retainer. Okay? See, there's the New York in me. But if you're going to do it, all right. Here's like, Tom's like, stay away. I'm a good guy. I'm like, oh no, you don't want to do it. But if you do, here's my trust account. Just wire the money right in. So there
Yeah,
Yeah.
you go.
I'm your one phone call, right?
Yeah, that's all.
So then if we think about all of the things we just kind of covered, right? The shadow IT of it all, the use policies and all those things. Like, what should MSPs be doing proactively, whether it's those policies or training, or like how can MSPs protect themselves? How can MSPs protect their clients and maybe sometimes protect their clients from themselves? Like how can we coverage some of those types of kind of legal guidance? And so Brad, I'd love it if you would just kind of share what your thoughts are there.
So from an MSP perspective, AI presents a service issue and it presents a privacy issue. Those are the two areas. It's service and privacy. Addressing service for a moment, um, and this goes back to what we were discussing earlier. MSPs would be well advised to start talking about AI solutions that they are using or that their third-party solution providers are using. Talk about what it can do, what they cannot do, right? What their limitations are. Make it very clear that, for example, ultimately the client is going to be the final decision maker about whether a solution or remedy suggested by AI should go into effect. They have to be the final decision maker. Okay, that's a service perspective. From a privacy perspective, I think that MSPs now have to start talking and educating their customers about the fact that they are using AI, both internally and by third party providers, and that the use of the AI necessarily, by definition, okay, comes with risk. Always comes with risk. You could say, well, look, we will, for example, use AI models and we will, to the best of our ability, if they allow us to, uh, disable the training model. So they're not going to use your data to train. Okay, still might happen, right? We're going to try to avoid, situations that might lead to AI hallucination. Still might happen. The idea is that on a risk-reward basis, right now the use of AI has far greater reward to customers than it does theoretically the risks on a day-to-day basis, but that has to be explained to the customer, both in the MSA through a service perspective and from a privacy perspective. This is where your data is going. This is how it's being used. We will endeavor to turn off training models, but it still might happen. Why? Because we don't control the training models and we don't control the AI. I think that greater communication is what is needed, and it is what is being avoided by incompetent attorneys in this area. And I am not blowing smoke. Tom is not an incompetent. He understands this. There are very few of us that do. But this is the issue that I'm seeing. Most attorneys that try to draft contracts in this area, they absolutely don't understand this perspective, and it will lead to a disaster.
Yeah, because your contract has two components to it. One, you have the MSP's use of AI, and that should be addressed in the contract. And you have the client's use of AI and how the MSP is going to monitor or not monitor that. With respect to the MSP's use of AI, the preparation is you control it, which is nice. You got to have an acceptable use policy. You got to set forth these are the tools that we are. You should map out where that information resides and where it lives. You should audit the usage to make sure that shadow AI is not being implemented. You should monitor your own team on that, and you should also train them. Train them not only about the AI that's approved, but the risks of using unapproved AI. You know, uh, clarify that it's not just a liability for the client, but it's also a liability for us if we end up disclosing something we're not supposed to disclose, both to the client, liability to the client, and to third parties, including the government. And then you should have some sort of approval process for betterment. Now, here's the thing that we haven't touched upon, that is just the absolute truth, and scary, scary, scary. When I first started practicing in 1991, um, when people had a lawsuit, they looked at the documents, the memos, letters, stuff like that that were generated, and then they relied upon testimony. And then you comes email, and email created a whole new stuff, and then instant messaging and direct messaging, and now you have Teams and Slack and all the different platforms, all you implementing AI, by the way. And now you throw on AI. The cost of litigation when I first started, you could get to a trial on a breach of contract case for $25,000 maybe. Not a super sophisticated one, but the type of deal that MSPs are dealing with, you get to trial at 20,000 bucks. Not do the trial, but get to the doorsteps. Most of them get settled anyway. You can't do that for 100,000 anymore. The discovery associated with everything in AI and emails and all the tech that we're using is just astronomical. Now, AI does expedite the review of the discovery, but I tell you what, people don't know where their information resides. And if you wait till the litigation happens and you're not backing it up, it's almost like in an M&A deal, we create a diligence room and we say, okay, here's all the stuff about personnel. Here's all our vendor information. If you have that all planned and you go to do your sale and you have it all prepared, it's not as hard as if you wait till somebody makes that unbelievable offer to you. Now you're scrambling to try to put everything together. Same is true when it comes to the MSP's use of AI. If you don't define it, communicate it to the client, map it out so that your organization understands, it's going to be really, really expensive for any sort of lawsuit that you have.
Brad, what are your thoughts on that with the discovery piece of it?
Really, there's nothing to add to it. He's right. The use of AI, the use of technology has created so many different avenues through which information is shared, disseminated, collected, stored, and so forth that, yeah, discovery has become, it was always in litigation, it was always the most expensive part of the whole thing. The trial wasn't the expensive part. The posturing, you should do this. No, we're not going to go sue us. That's not the expensive part. The expensive part was discovery. Discovery has now become exponentially more expensive. And even ironically, the fact that AI can make, as Tom said, the review easier, the diligence process itself is just, it's not for the faint of heart.
And 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 you can't rely on AI to tell you where all your AI is,
Right.
and say that to the judge. Well, I asked AI where it all was, and this is what it said. Because there's this concept called spoliation, and Brad, you could probably talk. You did much more litigation than I ever did. But in the spoliation thing, the judge gets to sanction a party. It could be a monetary sanction, or it can be a conclusion that this evidence that you can't find did exist and will be found against you when it comes to the point of trial. That's unusual, but it can happen.
Can
But
happen.
it's just the sheer cost, the ante. You're going to a poker table, and instead of having a $5,000 ante, it's $100,000.
Yeah, it almost so as I'm kind of been listening to you too and trying to think about again from the business side of the world, for kind of separating the business into the legal is it sounds like you need a use policy for the MSP, you need a use policy for the clients that and they need to care about that. But as the MSP, you also need to understand and map out where the data is and where the data is located and what's happening there. It's certainly internal and probably should advise clients to do that for themselves or make that be an offering for the client? Is that a fair assessment as to kind of the tenor of the conversation?
Yeah, and as you summarized there is also document retention policy. what is it called now,
Yeah.
Brad, when
I
it's
like to
all
call it
electronic?
document destruction policy, right?
Yeah,
Because
right, right, right.
it's not so much about retaining as much as when we're
Yeah.
going to destroy. But yes,
So you have the ability to have this policy that says we don't want to manage all this information, and so we just purge information that is X, months old or years old, regularly. And you got to do that with your AI. You got to get your AI into that program because the prompt is discoverable. Your responses to the inquiries of AI or the
search
AI
query.
generated responses are, and and we didn't even touch on this yet, Brad. But how many times have you encountered people saying, "I had this issue and I went to AI and I put out the facts, and AI said the following," right? I'm sorry, AI doesn't have attorney-client privilege. So all those facts that you just recited, you just set forth all of your fears in your litigation matter. You just set it all out there for them to discover, and when they find that
That search query.
smoking gun,
Hmm.
oh my God.
Yep.
Um,
When they find that search query and the results of the query and all, you're not going to be able to say, well, I discussed that with my attorney. Well, you also discussed it with, agentic AI. So you're
yeah.
right. There's no privilege.
And in our industry, Brad, I wouldn't be surprised if there was a law firm that said, we're going to have a tier of representation where you use our AI tool that we've created for simple questions where, you can get the attorney-client privilege because you're getting it through our firm
Our
and the
firm.
responses will be privileged.
Yeah, 'cause that makes a lot of sense though, is that if because without that client privilege, even like spousal privilege, becomes a challenge too, right? So, I mean, God forbid someone, to your point, Tom, puts a query into one of the free ones without any kind of restrictions on it, and all of a sudden you've just now exposed your secrets to essentially everybody to a degree. There's a lot of risk there, and I think so much of what we need to do, I think, and I think this video will help with that is to kind of start educating our MSP friends about some of the risks, right? And if we can like narrow it down to like one thing, if there's one takeaway from our conversation today, I want to kind of lean into each of you for that. So Tom, we'll start with you. What is your one takeaway? If someone's watching this and the one thing you want them to think about from today, what is that one thing?
Well, I'm kind of a revenue-oriented person, so I would just say you should explore bundling services around AI to dramatically expand your revenue.
All right,
I got
Brad,
a
same
close
question.
second, but
I like it. I like it. He's right because there's always a business aspect to all of this. We're not doing it for charity, right? We're MSPs are using this stuff to make money and to grow revenue. So agreed. I think that if I'm going to take another concept, I'll go sort of on the flip side of the same coin: communication. MSPs have to communicate, have to become more easily able to express their ideas to their customers. MSPs have to become more comfortable with talking to their customers about AI, how it's being used, what its limitations are, and what could happen. I think communication will manage expectations, which will result in fewer attorneys' fees, and that's what we want, sort of.
yeah, my
Right?
close second was you got to communicate it through the MSA or the contract relationship with the client so that you can limit your. But I'm such a revenue oriented guy, I just couldn't resist. Like there's this huge opportunity for MSPs to make money for their clients being their AI consultant.
Well, and I think part of it too is just we can charge for communicating with the clients too, right? Educating the client is not a free service, and you can put together some good collateral that you can use in a number of different areas too, right? This is a thing you can build it once and use it over and over and over again, even use it as a sales lead generation situation too, where you're sharing this at chamber of commerce events or other places or doing webinars or what, like you can create one good learning slide deck and talk track and use it to generate literal revenue and generate potential revenue as well. And you're mitigating some of this risk just by having those conversations from the jump.
I do want to caution too that I don't think a lot of MSPs are eager to attack this opportunity and that they will ignore it. And ignoring it is not going to save you from liability. In fact, really putting your head in the sand when your client is not and using AI is really problematic from a liability standpoint. because judges will look at it and say, they brought you in to do this, to do their technology management, and you didn't tell them about these risks. So the head in your sand doesn't work on this, I don't think.
Yeah, I agree totally. It's you know, you're supposed to be the IT advisor, right? If I go on your website, if I'm talking to an MSP, if I go on your website, what is it going to say? We are the IT experts, we're the professionals, and so on and so forth. And you're going to have a very difficult time if you don't follow what Tom just said, explaining things, be have more communication. Otherwise, it's just going to look like you put your head in the sand. And judges and lawyers, that's not a good thing. That's who you're going to deal with if you put your head in the sand. Hmm.
Awesome. Well, gentlemen, I really do appreciate you hopping on a call with me
Of course.
today. This was enlightening. I do also just like hanging out with you guys. And so, whenever I talk to anybody about legal stuff, I said this at the top. I'm going to say it again. You should talk to these two guys because they're both excellent at what they do, and I think that you will gel with one of them or both of them just fine in that. But I think it's important that you talk to multiple providers versus just picking the first person you talk to. So, with that,
Appreciate that. Yes,
thank you,
Yeah, I appreciate.
gentlemen.
How
I would.
rare is it, Brad, for us to hear that a guy who's not a lawyer likes hanging out with two lawyers?
I know it's strange. Well, he needs therapy, is what it means.
Yeah.
It's a cry for help, is what we're watching here. We're
Yeah.
watching. No, but I will say for anyone who tuned in, like, oh, it's Brad and Tom, they're competitors and all. We're not competitors. We're colleagues. I like Tom very much. He's a very bright guy. I've known him for years, and I know Tom, you feel the same way about me.
Yeah, I do.
And
I
so,
do.
yeah, I think that there are resources, and that you have to pick the right ones. Tom is one. I'd like to think I am too. So, thank you
Yeah,
for
you
having me
are.
on today. I
You
appreciate
are.
it.
Thank you, Tom and Brad. Great information as always, and I really enjoyed our conversation together. Yeah, I might need some therapy because I like lawyers, but it is what it is. If you found some value out of this video, please do me a favor, hit that like button. It does really help me in the YouTube side of things. And if you would like to hear more from me, I do release a newsletter about once a month. And I'm going to drop that link on the screen and in the description of this video. I will also put Tom and Brad's contact information in the video as well. I'm also going to drop a playlist up above for all things legal in the MSP space because that is a space in which I care very much about. So with all of that, thanks for coming on this ramble today, and I hope to see you on the next one.